Good morning, Bardstown and Nelson County, and welcome to Bradford and Brooks. And Jim Brooks and Margie Bradford will be with you for the next hour. And on this, I'll tell you, Margie, the temperature change was dramatic when I walked outside without a jacket this morning.
I know.
I'm used to 60s and 70s, and it was 41.
Yeah, we get used to that real quick, don't we? Yeah.
Well, I was, as I was leaving the house this morning, after the wind and the thunderstorms we had last night, I was taking...
Did you get hail?
No, I did not.
Oh, well, I got something that was pinging on my house really badly for about 20 minutes.
Really?
Yeah.
Well, now, I was watching the weather radar at 4:30 in the morning when I should have been asleep, and the core of the storm actually came south of me out in Cox's Creek and passed through Bardstown, so that's what you got.
Well,
you got more of it.
Right. Woke up at 6:15 with just being beaten to death with. And I mean, it was really funny. I mean, it went that way for like 15 to 20 minutes solid, and then all it was gone.
Right.
I mean,
Yeah, that's all we had at home was high winds, and so this morning on the way out, I had to check the front porch to check our wind speed indicator. If all the chairs are gone off the front porch, it was a sustained 60-mile-an-hour plus. But
and if the garbage cans are at the back fence, that gives it another boost.
Well, that's the joke at home that we used to pull furniture in off the front porch, but that's why God made fences.
Yes, stop it.
That's right.
So it's not rolling down the road.
That's right, or down to the neighbor's house behind me. All right. Margie, we have a special guest who's going to be joining us by telephone directly, Amy Bensenhaver. Amy, I'll tell you what, let's just get her on the phone. She's a former Assistant Attorney General, Kentucky Attorney General, by the way, and her focus has been on government transparency, and in fact, it still is, and we'll get the details from Amy right now. Let me see.
She's an expert on open records law.
Right. All right, let me see if I can get her punched up here. Get that off. All right. Amy, are you with us?
Yes.
Hello, Amy.
Hi.
I heard you at a meeting of the Democratic Women's Club a couple of years ago, so welcome back to Bardstown.
Thank you.
Well, Amy, Margie and I were discussing, before this show, we were in one of the things that prompted us to contact you. Well, she was, of course, your appearance with the local organization and discussing government transparency, but also some legislation that has been proposed in the State House. But we'll get to that in a moment. Tell our listeners a little bit about the work you did as an Assistant Attorney General, and what government transparency means to the average person. I'm a journalist, so I'm familiar with the open meetings and open records statutes in KRS, but those words may not mean a lot to the average person who doesn't have to, who doesn't deal with these things day in and day out.
Well, the Kentucky Open Records and Open Meetings laws were enacted in the 70s in response to a broadly held view that government was withholding too much information.
Right.
And so basically we enacted two laws in Kentucky, open meetings in 74, open records in 76. Both laws aimed at guaranteeing the public the right to monitor how government conducts the public's business.
Right.
So that we're not shut out, so that we know why decisions are made and policies are formulated. And so the goal is essentially to ensure the public's right to know how its government operates.
Right.
And one of the features of each law is the ability to appeal to the Kentucky Attorney General for a resolution of a dispute with a local or state agency over access to a meeting or over access to records. Those are decisions that basically are issued by the office within 10 days on open meetings appeals, and within 20 days on open records appeals. The citizen does not have to hire an attorney. The citizen does not have to be trained in the law. So one of the great beauties is that it enables any citizen to vindicate his or her rights under these laws, and get a resolution within a relatively quick turnaround. And that is what I did for those 25 years as an assistant attorney general, exclusively focusing on dispute resolution involving open records and open meetings, training, publications, outreach, to try to make sure that every public official knew his or her duties and that every citizen knew his or her rights.
Right, and I think, Margie and I had talked about it, I think last week, and she was telling me some of the circumstances that led to the creation of the law, because there was nothing before it was actually established in the 1970s.
Yeah, it's an interesting backstory, because the first FOIA laws, Freedom of Information laws, were enacted at the federal level under Lyndon Johnson in 1966. And the story goes that Lyndon Johnson reluctantly signed into law a bill that had been, aggressively pushed by a representative in Congress named John Moss. But it's a very hysterical story, because he's reading all of this lofty language about the public's right to know, while he is literally gritting his teeth and signing the bill into law. So the reality is we've had a form of FOIA, or Freedom of Information, at the federal level since the 60s. But in the wake of revelations about secrecy associated with the Vietnam war, and also with Watergate,
right,
there's a level of appreciation at the state level that we needed something equivalent to guarantee to secure those rights at the state level. And you see a lot of states in the 70s enacting these laws.
Right. Now, why is this? Why are these laws important to John Q. Public, who, the public tends to be the benefactor of these laws when they are enforced, but they may not know appreciate just how important it is to have government transparency.
Right, and that is the beauty of our law. It is expansive. It extends to public agencies in a very broadly defined sense. Any governmental entity, any entity conducting the public's business. So, from everything from a state government cabinet, the Cabinet for Health and Family Services, down to a local water district or a site-based council at a public school. So the reality is it's a broadly defined term and a broadly applicable law that enables the public to know, for example, if our school is considering a dress code, what is the discussion? Why are we considering this? If the county government is considering some sort of tax increase, what is the motivating factor? Why are we looking at this? If we're looking at the state level, and I mentioned the Cabinet for Health and Family Services, at a very dramatic level, in the early part of, in 2010 to 2015, we were engaged in a battle to access records that demonstrated that the cabinet had failed to provide adequate protection for children under its supervision who subsequently died under horrific circumstances, and basically was essentially trying to resist disclosure of the records relating to those child fatalities and near fatalities, because it exposed deficiencies at the Cabinet for Health and Family Services, and ultimately was required to disclose those records, which resulted in really positive changes. The problem is still there, but positive changes has been made to address child fatalities and near fatalities of children, helpless children under the supervision of the Cabinet for Health and Family Services. So you can literally go from the most minute little issue that might affect a locality to these broad issues of life and death, quite literally. At the state level, this law encompasses everything and ensures that the public has a right to know how and why things are transpiring in government as they do.
Amy, this House Bill 509, which would just turn this open records law upside down. Can you talk about the particulars of that proposed legislation?
Okay, there's a little bit of a backstory. First of all, the issue of access to discussions of public business by public officials or employees on their private cell phones or devices. In other words, this is a case that is currently in the Kentucky Supreme Court on petition for discretionary review, meaning the Supreme Court may or may not hear this case. But this case has been resolved in favor of the public's right to know. Basically, the court has said a public official or employee cannot evade the open records law by conducting public business on their private cell phone. To the extent that those records relate to public business, they are public records, and to the extent that they are not protected by an exemption, they are accessible to the public. So this is the case that the group I work with, the Kentucky Open Government Coalition, is involved with, and our opponent is the Kentucky Department of Fish and Wildlife Resources Commission. The commissioners were not assigned public email addresses. They were conducting all of their business on their private devices. When we asked for their emails, we were denied access in part, the ones on their private devices. So bottom line is that that's the backstory. So because this issue has generated a lot of controversy, I can tell you that virtually every state in the United States that has looked at this issue recognizes, as Kentucky recognized, that these are public records. You cannot evade the open records law by using a private device or account. So based on that, a representative, a freshman representative in his second year, John Hodgson, from Jefferson County at Fisherville, which I'm not familiar with in Jefferson County, but he sponsored a bill along with Jason Nemus and David Osborne that has two essential parts. It actually has three. The third part is positive, so we won't even discuss that. But the first part basically requires, mandates, codifies the duties of public agencies to assign public email addresses. That should be standard operating procedure, but to the extent that it's not, go for it. We are perfectly content to make that statutory mandate. It also provides that officials and employees, commission members, board members must conduct the public's business on their public devices or risk some kind of discipline. It doesn't specify. It even would go up to include removal. So ultimately, but it doesn't specify, the degree of severity, or so it's a little bit nebulous. But the truth is, that part of the statute doesn't really bother anybody. What has really caused grave concern is that section that follows that has to do with redefining the term public record. Essentially, like the definition of public agency, the definition of public record in Kentucky is expansive. It really basically covers anything, and it does not have to be. It's a record that's created by, retained by, possessed by. In other words, it's a broad definition, but it doesn't have to be physically possessed. That is very clear in the law. So the reality is, this bill would essentially say, a public record is a record only accessible to the public only if it documents or records or reflects a transaction, which is a term not defined in the statute, or final action, which means essentially, and they go on to describe in the statute, what that would be: a contract, an invoice, a letter of discipline to an employee. But nothing that precedes that would be a public record, because it then goes on to say the following shall not be public records. Sorry, that's my phone. It goes on to say what is not a public record is a draft, a note, correspondence with private individuals. What are currently exemptions to the open records law suddenly become non-public records. But ultimately, what's critical is the final exclusion from the definition of public records is precisely for any communication on a private device, any information contained on a private device. So essentially, it reopens that huge wound. It creates that potential for massive abuse. Ultimately, that's what the statute does. There's a provision relating to open meetings that simply makes a meeting conducted in a location that does not afford the public adequate space, seating, acoustics. It would make the action taken at that meeting voidable. That's a positive. We don't worry about that.
Right.
It's that redefinition of public record. It's essentially saying to the public, we're going to decide. You get to know the final action. Stuff that would normally just appear on an agency's website. But here's a contract. Here's, if you were a licensure board like the Board of Medical Licensure, the Board of Nursing, you're going to put up their disciplinary records. If a nurse has been disciplined, a doctor has been disciplined. These are all things that would normally just be on an agency's website. They're saying under the Open Records Law, this is what you can get. But anything pre-decisional, anything that precedes that final action is exempt. And overall, what is exempt is anything on a private device. So ultimately, it has a devastating impact. It will strip our law of any meaning. And I can tell you that I talked to experts when I first saw this bill, national experts. I'm fortunate to have contacts, and they're pretty good contacts. And I was told that if this bill passes, Kentucky will be dead last in rankings of state public records laws. We will be at the bottom. And frankly, the expert I spoke to said, frankly, in the world, every country has an equivalent of a public records law. Some are good, some are bad, some are abysmal. We'll be down with the abysmal countries because we will not have access to anything of any value. So ultimately, it is a devastating bill.
Absolutely, and it's scary to me that the exclusions, as far as the leaving the final action as the discoverable record, and because we've had situations here in Nelson County where a wrongdoing was uncovered solely through a chain of emails, between elected officials,
right,
and appointed officials. Pardon me. And without the ability to request those records, that wrongdoing would never have come to light. Never. Right.
Yeah.
And so that's I understand the importance of it, and I joke with Margie all the time, but in this case, it's true. I was disappointed to see House Speaker David Osborne as a co-sponsor on this legislation. Because I'm a Republican, and as I tell Margie frequently, sometimes members of my own party make it hard to remain a Republican.
I've told him the Democratic door is open.
Well, the truth is, I will be 100% honest with you. There have been abuses through time by people in power. Mm-hmm. The reality is about open government laws is that they are as much a nonpartisan issue as you will ever find. Across the political spectrum, people respect and value public records laws. Either end of the political spectrum and everything in between. Who does not respect public records laws are people in power. And what they don't like is the light of public scrutiny being shone upon them. And what they will do is fearmonger and misrepresent what is being required. And in this case, what they are arguing is, in fact, Representative Hodgson said, this is going to be a good way of recruiting talent to Kentucky, because right now, and this is absolutely false, and I emphasize that, absolutely false, he says right now, he was wrong about this, and I think he acknowledges, I hope he acknowledges, he was wrong, that a public employee or official would be required to hand over their private cell phone to an agency's custodian of records or an open records requester to rifle indiscriminately through, just go on a fishing expedition, through private and public text. So the reality is that is absolutely untrue. Mm-hmm. The Court of Appeals made that absolutely clear. That question was presented to the coalition's attorney, Michael Abadi, in oral argument. We had discussed it at length, and absolutely not. No one has ever asked for a private cell phone to be surrendered. No one has ever asked to make an indiscriminate fishing expedition through someone's private and public texts. So the reality is, like any other open records request, when the request comes in to the custodian of records, that person sends out feelers. He or she sends out feelers to anyone in that agency that might have responsive records. Please collect all of the records you have that relate to this subject and forward them to me. That does not mean they roll their file cabinets into the custodian's office. No, what that means is the individual pulls the responsive records, forwards them to the custodian, and the same would be true here. The custodian would then, working with agency counsel, determine which must be disclosed and which may be withheld. So the reality is this is fear-mongering, this notion that people are going to have to surrender their private phones, and the Kentucky Court of Appeals made that 100% clear. So the fact that we've got people, and it's not just it's not just Speaker Osborne, but it's, attorneys like Jason Nemus who can read a case and know that that is not what the court said. It has never been anyone's expectation. It has never been anyone's right to require the surrender of a personal cell phone or computer. I will say that if it's ultimately determined that someone withheld a public record, there are penalties that can attach. They concealed it. They wrongfully concealed the record. There could be penalties that attach, but that does not mean surrender of cell phones. That means monetary penalties. So, yeah. So, the law works so well. The law works, I came to this law in 1991. It was not very old at that time, 76 to 91. There had not been a huge number of developments. But over time, as digitization and automation and electronic record keeping became the norm, this law adapted perfectly. So the idea that we need to go in there and change it is so deeply offensive and arguably by people who know infinitely less and are unwilling to consult with people who do know something about this law is deeply, deeply offensive.
Well, Amy, I know that here in Nelson County, and this goes back a number of years, we had a situation where our city council, they all had private emails, and there were some open records requests for email correspondence, and that request caused a lot of heartburn about how do they comply with it, and at the beginning of these elected officials' terms, he suggested that they go to government emails, and you only do business on an official email account. And, they hadn't done that ever in the past, so that suggestion was just a suggestion. However, it was something that actually would have borne fruit and saved them a lot of heartache about having to go through all their combined personal and official emails to comply with the open records request. But I think both the city and county government now, and county government now's in the now working to get everybody, all the magistrates on official to do their business on official accounts now, just to avoid issues in the future.
Yeah, it was interesting at the circuit court level, Franklin Circuit Court level, Judge Wingate, the attorneys for Fish and Wildlife Commission basically argued how burdensome this would be. And Judge Wingate simply said, listen, that's on you. You choose to conduct a public business on a private device. You are responsible for retaining that as a public record. You don't get to destroy it at will. You don't get to delete it. You don't have any of those options when it comes to a public record. You are responsible for managing it as a public record and ensuring that it is accessible in response to an open records request. And if you're not doing that, that is on you. So the truth is, I think that the first part of this bill is an attempt at doing something positive.
Right. I
also believe in my heart of hearts, and having witnessed the duplicity of government officials through the years, there's going to still be some bad actors who continue to act badly. if they're really hell-bent on secreting away public records, they will continue to do so on their private devices. But we can deal with that on a case-by-case basis. What we need right now is a recognition that these are public records, that they must be managed and retained as public records, that they are not subject to random deletion because they're on my private cell phone, and that, frankly, that I am just as accountable if I do the public business on my private device as my public account.
Right, and the Kentucky Open Records law has, and I can't remember how many exemptions there are in that. Because
18 currently. Every year we get a new one.
A new one, right?
Yeah.
But the law is pretty generous as far as what entities don't have to reveal.
Right.
Right. and as a journalist, we have to keep track of what the latest changes are. But I found most governments are responsive. They may not. I mean, Open Records it's a responsibility of the agency to put the information together. So I try to not have requests that are expansive. I try to keep it narrow into a certain point. But anyway, I found our local agencies are generally pretty responsive to requests, and as a journalist, that I appreciate that.
Yeah, I think even in the time I was in the Attorney General's office from 1991 to 2016, I can tell you that there was a palpable decrease in the level of respect for the law, the view that it became more common that this law was a nuisance. I think it does definitely place an additional responsibility and duty on a public agency, but that duty is every bit as important and statutorily assigned as any other duty of that public agency. So they can't give it, put it on the back burner while they do their important work, their quote-unquote important work. They have to give it the same status and importance. And I will say, again, you're exactly right. For many, many years, we had about 12 or 13 exemptions. Now we annually get these kind of weird exemptions, one of which is for communications of a purely personal nature. So, again, we're not going to see anything about, my chemotherapy treatment or my with my divorce lawyer. We're not going to see that stuff. We're only going to see stuff that relates to the public's business. And that's under an existing exemption that's been in the law since 2018. So the reality is that the exemptions that exist in the law, that's where the disputes arise. That's where we go to court or we go to the Attorney General for resolution. And again, it works fairly well. We protect personal privacy. We protect economic development. We protect preliminary documents to the extent they do not form the basis of a final action. If someone makes a strange, bizarre recommendation that goes nowhere, we'll probably never see that because it would be deemed a preliminary document. But those that become the basis of or form the basis of final action should be disclosed. We want to know why our policymakers made the decisions that they made. The statute says, the Open Meetings Law says, the formation of public policy is public business and shall not be conducted in secret. The Open Records Law says free and open examination of public records is in the public interest. These statements of legislative intent have existed in the law for decades.
All right. Well, Amy, we need to take a quick break to get some commercial messages in. And you're listening to Bradford and Brooks and our very special guest, former Kentucky Assistant Attorney General Amy Bensenhaver. We're discussing open records, open meetings, and transparency in government and how important it really is, even though in our day-to-day lives we may not think a lot about it. But and in House Bill 509 that would change some of those statutes for the worse, we think. Anyway, we will be right back with Amy after these messages, so stay tuned. All right, you're back with Bradford and Brooks. Margie Bradford and Jim Brooks back with you till the top of the hour. And then stay tuned to WBRT for the best in state and local news. And our special guest by telephone today is Amy Bensenhaver, a former assistant attorney general with the Kentucky Attorney General's office, whose focus was on the state laws governing basically government transparency. And Amy, you're still with us. I hope I hit the right button.
Yes.
All right. Very good. Well, Amy, just to switch gears a little bit, I know that after you left the Attorney General's office, you were co-founder of a group basically that focuses on educating the public regarding the government transparency. Would that be a correct description?
Right. After leaving the Attorney General's office, I was kind of at loose ends. I didn't. My departure was not entirely voluntary. So ultimately, So ultimately, I was kind of at loose ends and looking for ways to use the skill sets that I had developed. And in 2019, there was a particularly bad bill that was introduced, and a lot of folks were sort of communicating about the bill. And a woman named Jennifer Brown, who was the editor of the Kentucky New Era, and is now the editor of a local newspaper called the Hoptown Chronicle. Jennifer and I started talking about the fact that in Kentucky we do not have a voice for the public on open records and open meetings issues. That voice is provided for media by the Kentucky Press Association and the Kentucky Broadcasters Association, but the reality is the public's voice is often overlooked. And although those voices are often in harmony, there are occasions when the public's voice is subordinated to the media's voice. And so on those occasions where we in particular have supported greater transparency than the Press Association, we thought it was important that we have a level of independence. And so we basically formed the Kentucky Open Government Coalition. Because I'm retired, because I'm a pensioner, I can do this free of charge. I help people regularly across the Commonwealth. I answer questions. I blog a lot. That's my great joy, because of course I spent my career writing, and writing is a great joy. So, and I'm also free to say exactly what I think. For many, many years, for those 25 years in the Attorney General's office, I had to be very cautious about what I said publicly. And so now I'm free to say exactly what I think and step on as many toes as I want to. I want to be respectful. I truly do want to believe the best in human nature, but time and time again, human nature proves me wrong. So yeah, the coalition exists essentially to alert the public to these dramatic threats to the law and to ensure that they have a voice in Frankfurt on these issues. And that's why Jennifer and I created the coalition. We're still kind of in our infancy, but we are entering into our 5th year. So I feel pretty good about that.
Can you give me the name of that coalition again exactly?
Yeah, it's the Kentucky Open Government Coalition.
Okay, thank you.
And I will say that virtually every state in the United States has an equivalent. They go by different names. Tennessee's is Coalition for Open Government. Virginia, virtually every state has one. And most of us participate in the National Freedom of Information Coalition, which is sort of the umbrella agency, but we're all quite independent. And some of these they've been around for decades, so they have a lot more resources, a lot more staff. We're basically just a very small group with a board of directors and basically trying to do good work.
Well, how can people find out more about the Kentucky Open Government Coalition? Is there a website?
We do have a website, and I am so technologically challenged that I can't tell you the website address. But I'm sure if you type in Kentucky Open Government Coalition in your search bar, it will pull up our coalition's website.
Excellent.
Yeah. I apologize. Yeah, and we also post on Facebook. I have my own Facebook account, and then the coalition has a Facebook account. And those, that you'll see more on our Facebook account because I'm monitoring what's happening across the country And there are parallels. There's so many parallels that it's important to know. For example, on this issue of public discussions on private devices, how pervasive this issue is, and how 99% of the time it's resolved in favor of the public's right of access. So the fact that Kentucky is going to look like a big bunch of big dumb clucks if we enact this law as written, or if Representative Hodgson makes the promised changes, and then other lawmakers come in and amend the bill and achieve what they set out to achieve at the beginning, which is a very real possibility. Whatever Hodgson's intent, I don't know the man. I don't know legislators, and frankly, I'm thankful for that. But the reality is, if Hodgson has committed to change the bill, we'll know in the next several days whether that's a commitment he will live up to and how well he will live up to it. But our fear is that he will make those changes, and ultimately other lawmakers will step in to amend the bill, and that's a frightening thought.
Well, what can the average person, listener here in Nelson County? We can call call Frankfort and get messages to our legislators about our concerns about this legislation, I guess.
Yeah, I'm probably less knowledgeable about the best way to sway our legislators. I will be honest with you. I don't want to be a pessimist, but it's just that sense that I have developed over time that these guys are kind of shameless, and they will do what they are intent on doing no matter what the public outcry. However, that public outcry should be there. Absolutely contact your lawmaker. And beyond that, think about that when you go to the poll, because what I keep saying is, and I mean this, absolutely mean this, these guys live in an echo chamber. They're listening to each other. They're not listening to their constituents. Their constituents are saying to them, their voters are saying to them, protect and preserve this law. Do not mess around with this law. And if they listen to the people who elect them, they will keep hands off. And that's what's so important here is we think we're making progress with Representative Hodgson, that the people have spoken and he has listened, but will his colleagues listen? Will other legislators honor the wishes of the voters who placed them in office? And if they don't, they should be accountable at the voting when people go to vote.
Right. Well, it concerned me that the House Speaker was supporting this legislation. That I'm sure that kind of telegraphs, that others in the party should fall in line, I guess. But
I think this has been on the agenda. I think that they have had this on the agenda since the coalition began winning these cases. We won, Franklin Circuit Court, that we won last October in this Court of Appeals in a published opinion, and that's significant. And they, within a month, of course, they had to petition for discretionary review, meaning they are asking the Supreme Court, the Fish and Wildlife Commission, to take another look at this issue. I don't think there's any gray area here under existing law. I think Judge Wingate recognized that at the Franklin Circuit Court level. The Court of Appeals recognized it, and I think what they're hoping to do is change the law so that ultimately whatever governed the law in the past will change with this new bill. And it's a terrifying thought, because Kentucky will, as I said, our open records law will become a farce. People will only be able to get that which they can already obtain by looking at an agency's website. Right. Yeah.
Well, it basically guts the law and makes, I can't. I don't know. Well, of course, that's one reason why we contacted you, to have you on to kind of sound the alarm here, that and give us some background and why the government transparency is so vital, even though it's not something that my wife and I talk about at the supper table every night. But it's part of protecting ourselves from government and keeping good government.
And I think people become aware of that when there's a local issue that impacts their lives. And I gave that example of something as simple as a dress code in a school. and the site-based counselor, whoever's making the decision, we want to hear that discussion. We want to be able to be present, to make our presence known and our opposition or our support known. This is just the opportunity for the public to be, it's participatory democracy. As James Madison said, knowledge will forever govern ignorance. If we mean to be our own governors, we must retain access to information. That's why Madison is considered the founding father of open government. But yeah.
Well, Amy, we're getting down to the wire here on the show. A few minutes left. Any additional thoughts you might want to share with our listening audience, or questions we hadn't asked you yet, or other important points you want to make in the last few minutes?
Well, again, I think it's way too early to celebrate. I mean, I do think Representative Hodgson has shown some good faith. I also am concerned that there are others who may not be so faithful, and that we need to continue to be vigilant about this bill and to make our voices heard. And if they're not being heard in Frankfort, then they need to be heard when we go to vote locally, because that's the frustration. It's almost as if, in spite of, for example, when the legislature removed itself from the application of the open records law, this was a major defeat for open government. If anyone needs to be monitored, it is the Kentucky General Assembly. So the reality is, when they remove themselves and the same guys come back to Frankfort every year, it's just a frustrating thing to see them rewarded for their bad conduct.
Right. All right. Well, Amy, we got a little bit of time left, but I'll go ahead and take a moment. I want to thank you so much for being our guest.
Thank you.
Happy to do it.
We appreciate your expertise and your willingness to share it with us. And maybe we can get together again and discuss how the session ends, and hopefully for the better for the government transparency will survive.
Right, and keep an eye on Frankfort right now, because again, this is where the rubber hits the road. This is the critical time, and I'm already hearing rumblings that this discussion we've been having with Representative Hodgson is not the end of the story. As I said, if that is the case, and if there is a plan underway to basically reinsert the bad definitional sections, if that plan is underway, those elected representatives need to learn that there are consequences for betraying the public's trust.
Right. Now, what's the name of the state representative that...
His name is John Hodgson, and what I learned about him was that before he was elected, he himself was a citizen activist. I don't know what end of the political spectrum he's a Republican, I guess, but the truth is that he himself understood the value, and he said, I've used open records. I don't know how regularly he used it. I don't know how much frustration he experienced, but it was, as I understand it, what he has said is it was people like him, his former self, citizen advocates, conservative groups like Americans for Prosperity, who came forward to say, do not change this law. They were absolutely speaking with one voice, along with the Kentucky Press Association, along with the Kentucky Open Government Coalition. On this issue, we are united. The only people who do not understand this are the people we send to Frankfurt. and that is really an unfortunate situation.
Right, absolutely. Well, Amy, we're getting down to the wire. I will, again, many thanks for coming on, and we'll be in touch as things progress.
100%. It's good to talk to you guys. Thank you.
Thank you, Amy. Have a great day.
You too. Bye-bye.
Bye-bye. All right, Amy Bensenhaver, former Assistant Attorney General, who for 25 years was their go-to person for open meetings and open records disputes. And I'm almost sure she weighed in on some of the local cases when there were disputed records.
I'm sure she did.
So, anyway, we appreciate her willingness to talk to us today by telephone.
She made reference to the fact that her departure was not entirely what she wished. What she did not say was that our former Attorney General pretty much purged the Attorney General's office of anyone who did not agree with him.
Right. All right, Margie, well, we're out of time. Thanks for coming in, Margie. Always great to be with you.
Thank you.
All right, that's it for Bradford and Brooks. Have a great week, everybody. We'll see you next Wednesday for another Bradford and Brooks.